If it pleases the court, my name is Wessels initial C, and I appear with my learned junior LAWS11064 initial B for the defendant Cafe Urban Eats. Your Honour, this case revolves around the question of duty of care bestowed upon my client towards the plaintiff while he is inside the cafe with his family, and if my client's level of care provided was reasonable to ensure the safety of all patrons in the establishment on that given evening. Your Honour, the Cafe Urban Eats is a small establishment that can accommodate around 40 to 50 patrons at a time. It is an unlicensed cafe and a trendy restaurant and bar precinct on the Sunshine Coast. The cafe operates late on Friday, Saturday and Sunday evenings. Your Honour, the question remains as to why my client should be held liable for the action of other third parties that attacked the plaintiff off my client's premises, after my client took all reasonable precautions to ensure that the plaintiff and his family left the cafe safely. Your Honour, as with all negligent cases, the plaintiff must prove that my client owed a duty of care, that the scope of that duty, that my client breached that duty, and finally, due to my client's actions or lack thereof, that the plaintiff suffered some form of real damage or loss. Your Honour, the defence plans to present two submissions. The first submission is that my client Cafe Urban Eats provided the required level of care to the plaintiff as occupier of the premises, that my client did take reasonable measures to control rowdy and intoxicated patrons from tortious actions of criminally injuring other patrons. The second submission addresses why my client is not in breach of his duty of care to ensure the offenders had left the premises and on ensuring the plaintiff was safely escorted to his vehicle. Your Honour, let us consider the scope of the duty that was shown in the case of Australia Safeway Stores and Luzna. Their Honour stated on page 27 to 28, an occupier of land is under a general duty of care to a person entering on the land, whether as invitee, licensee or trespasser, independent of any special duty, where there are circumstances giving rise to general duty. As in the Civil Liability Act, Section 5B, under the heading General Principles, a person is not negligent in failing to take precautions against a risk of harm unless the risk was foreseeable, the risk was insignificant, and the circumstances a reasonable person in a person's position would have taken those precautions. The harm, Your Honour, that was suffered by the defendant was caused by the criminal and tortious actions of a third party. The harm suffered, both physical and psychological, by the plaintiff was not a reasonably foreseeable repercussion, and thereof novus actus intervenus was out of the scope of liability, such as it would be unfair to hold the defendant liable to hold the defendant liable for actions of a third party which caused his injuries. As per the case Packer and Tall Ship Sailing Cruises Australia, in this instance in December 2006, the plaintiff was the victim of a sudden and unexpected assault. The assault was committed by unidentified assailants at the end of a work Christmas party on a cruise operated by Tall Ship Sailing Cruises Australia. Your Honour, the injuries caused by the unforeseen attack, which resulted in the physical and psychological injuries, was not a direct result of the defendant's actions, Your Honour, as per Modbury, Triangle and Ansell, where the High Court held that the owner-occupier of a shopping centre did not breach his duty of care to an employee of a tenant who was attacked in an unlit shopping centre car park. Your Honour, the manager Rush Rogers did take reasonable actions against the two offenders, Ben Jansen and John Scott, as he did not view them as completely inebriated or out of control when they arrived at the cafe, prior to Nate Oliver and his family arriving. Nate went and took a seat next to the offenders, which further illustrates that they were not being rowdy and extremely intoxicated at the time. Your Honour, the manager had also never seen the offenders, so they had no prior knowledge of their conduct and possibly their reputation. He also stated that they did not in his eyes pose a threat to any of the other patrons, as they were occasionally loud swearing and a little agitated with each other. This type of behaviour was nothing out of the ordinary for some of the cafe's evening patrons, and there was little to suggest that it would escalate as it did. Your Honour, let us consider Deals Palace and Mobarak. This case confirms that intoxication is not a necessary element to invoke the duty owed by a hotel and club to protect its patrons against the tortious or criminal conduct of fellow patrons. The duty of care owed by clubs and hotels extends to taking reasonable care to guard against injury from intoxicated, unruly or violent behaviour of other patrons. Let it be known that the premises in this case was a licensed premises. The duty arises because of the foreseeability of injury from conduct on the premises and the capacity of the defendant to control that conduct. Your Honour, as per Section 5B of the Civil Liability Acts of Queensland, General Principles, the defendant is not negligent in failing to take the required precaution against the risk of harm. In determining whether a reasonable person would have taken precautions in the risk of harm, the court is to consider the following: the probability that the harm would occur if care were not taken, the likely seriousness of that harm, and the burden of taking precautions to avoid the risk of harm, the social utility that creates the risk of harm. Your Honor, the defendant did take reasonable care and precautions to ensure a third party who caused physical injury and consequential psychological injury did leave the premises and move to a different location. One cannot expect the manager to follow the patrons outside of the premises where he is employed, as once they exit the business and move on, which the manager at the time did take reasonable steps to ensure they left and walked in the direction of another establishment. Cafe Urban Eats' duty of care did not extend to taking reasonable steps in following Nate Oliver to his vehicle in the car park to prevent injury caused by criminal acts of third parties over whom the defendant had no control once they left the premises of Cafe Urban Eats. The decision in Marbury forms part of a list of cases where consideration had been provided to whether and when a person owes a duty to take responsibility and reasonable care to control the actions of third parties. Your Honor, the defendant also allowed the plaintiff to exit the premises through a side entrance, which further demonstrated that he wanted to ensure that they do not cross paths with the third parties if they left them at the front entrance. He did take all the reasonable precautions. Your Honor, as per Modbury, Triangle and Ansel, as well as Carel and Deakin University, which was a 2012 case from the Supreme Court of Victoria, also viewed in favour of Modbury Triangle. The duty of an occupant of land does not extend to taking reasonable care to prevent harm to others resulting from the criminal behaviour of third parties at unlicensed premises. Your Honor, as per Civil Liability section of Queensland Section 5D General Principles, a determination that negligence caused particular harm comprises of the following elements: that negligence was a necessary condition of the occurrence of harm, and that it is appropriate for the scope of negligent person liability to extend to the harm caused. There was also no special relationship between the defendant and plaintiff, Your Honor, which was sufficient to prompt a duty of care that would extend to safely measures to protect the plaintiff from the risk of injury at the hands of third parties outside the car park, which is public property. Please see Carel and Deakin, as well as properties of Strata, Plan and Draculin. Your Honor, my learned junior Zwart Initial B will now discuss the second submission in more detail and provide you with conclusion of our case. Thank you.